an ethics opinion published, RI-374, I almost said 376, 374 there, which essentially says that attorneys have an ethical duty to complete a succession plan. So it was one of the first big steps towards what we have today. I don't know how many of you guys are familiar with what the AGC has been doing for succession planning, but essentially they have this receivership program where they would take only about 10 to 12 cases a year for attorneys without succession plans, or their successor was unable to act. And they would actually open up this receivership where the AGC would go in and wind up these law firms. They really don't have a lot of manpower or resources to commit to this project. Their budget was around $10,000 a year, which can get eaten up quite quickly. So it was always ever a Band-Aid for this problem, and never a full-blown solution. So once the state bar really got going on this, it became very apparent that our resources, our ability to track attorneys, we were going to be the best agency to complete this mandatory succession planning. And that's kind of how this came about. So yes, like Mark was saying, these rules are effective September 1st of this year. There are changes to the state bar's rules. That's where you get Rule 21 from, because that is a whole new state bar rule. Additions to the Michigan court rules as well. So that was officially adopted in June of 2022 by the Michigan Supreme Court. And again, effective this September 1. So what are these changes? So what are we requiring? The bulk of the requirements are for private practice attorneys. And we're defining that as attorneys who use their Michigan, who have clients that they use their Michigan law license for. So for whom they use their Michigan law license. And that's how we're going to define who is a private practice attorney. So if that's you, and if you have questions on if you are, feel free to reach out to me as well, because I've taken quite a few of those and we've gone through, okay, yes, should you answer yes or should you answer no? So if you are answering yes, you would then be required to designate an interim administrator and name a person with knowledge. So what is this? So person with knowledge, this person knows where the actual and virtual keys are located. To the office, that they could be a family member. It doesn't have to be an attorney. It could be a staff person, paralegal, legal assistant, secretary. This is someone who is going to assist the interim administrator when it comes time to act, be able to say, okay, yep, this is where, these are our active files. These are past clients. Just someone who is able to give that knowledge to the interim administrator. It can be the interim administrator as well. So if this person of knowledge is also your interim administrator, they can be the same person. So it can be anyone. So this interim administrator, there's two options when you're naming this. We have the no cost option, which actually has two options in it, and then the cost option. So really altogether, you're going to have three. And I'm going to show you how that breaks down on the State Bar's website as well when you're going to designate it. But essentially, we're saying option A is no cost and option B is the cost option. So let's go over the no cost option, the name your own option. So again, no cost to you. It would take your time to conduct the planning, of course, but no monetary cost. This can be, so when you're nominating this person, it can be an active Michigan attorney in good standing, other than yourself, or a law firm with another active Michigan attorney in good standing. So if you're employed at the law firm and you want to name that law firm as your interim administrator, you can do that. And I'll show you exactly how that's done the second half of this presentation. So when you're nominating a law firm, if that was your choice, you would be also attaching an attorney to accept the nomination. So the state bar doesn't track law firms, so we're unable to say, okay, we're sending this nomination to the law firm. We need to send it to an attorney who's employed by the law firm so they can actually accept the nomination. So the cost option, so this would be if you didn't have another attorney to name as your interim administrator, and you needed to, or a law firm, and you wanted to enroll in this program, this is kind of the option where you can just click, hey, I want to enroll in the state bar's interim administrator program so that they are taking over or finding an attorney for me at the time that I am unable to practice. And that's where this option comes in. So this would be where you would pay a $60 annual fee, and you wouldn't really have to worry about anything else. When you became unable to practice, the state bar would be acting as your interim administrator, or we would be finding you one. So when would this interim administrator act? So the main goal of this program or these changes is to protect the public. So we want to make sure that if something happened to an attorney that has clients, that the clients aren't just left in the lurch, and also that the attorney's interest in their law firm is protected. That's another goal of this program. We want to make sure that those goals are met. So an interim administrator would only act if the attorney becomes an affected attorney as defined in Michigan Court Rule 9.301 A. So these are the reasons listed in the rule: resigned, disbarred or suspended, disappeared, imprisoned, abandoned the practice, disabled, whether it be temporary or permanent, or transferred to inactive status, and of course, passed away. So circuit court appointment of an interim administrator is necessary unless there's this very specific provision in the rules, Michigan Court Rule 9.303, which talks about if you are naming your own law firm. So we wanted to make this as easy as possible because we know some mid-sized to larger firms already have been doing this succession planning. They already have that worked into their employment contracts, anything like that. So we wanted to make it fairly easy for them. So in that scenario, no circuit court appointment is needed if the firm that you're employed at, or that is your firm, is your designated interim administrator. There is another active Michigan attorney in good standing who can competently represent the clients, and each client gives their express written consent to be represented, and those must be maintained in the client file. So we've been talking about this and how that would look. This can be something that you're getting after the fact, and it's probably best to do both, what I'm suggesting, but it can also be something where you're building into your fee agreements this expressed written consent, and then also doing it after the fact would probably be best practice, but it is something to consider where you could build it into your fee agreements. Okay, any questions so far, Mark?
None so far.
Okay. All right. Perfect. Okay. So what is required of an interim administrator? So there are some duties listed specifically in the court rules. So 9.307 B and C list these specific duties. And this is going to be on those standard. I'm going to talk about some scale forms that hopefully are coming. Nothing's been published yet, but we'll talk about those. This is what's going to be standard on those forms for the duties. But we're really wanting to suggest and hint very strongly to these attorneys that, you can enter into an agreement with your interim administrator. You can personalize those duties. You can put specifics into what would dictate a certain action. So, okay, if I'm disabled, this is what would be done. If I have passed away, this is what would be done, because those are going to differ. If it's a temporary disability versus being passed away, or a permanent disability, those actions of your interim administrator might differ slightly. So definitely enter into an agreement with your designated interim administrator. And we will have forms, and I'm going to talk about that at the end here when we talk about resources. Okay. Mark, it looks like I am able to see the chat, and I do see a question. So let's
Just popped up. Okay, when you use the paid option, so the $60, is an administrator named on enrollment, or does that occur only if there's a triggering event?
Yeah, that's a great question. And it would be the triggering event. So back where we're talking about the affected attorney. So you nominate your interim administrator or you enroll in the program. So now you have a designated interim administrator. The matching of an attorney from the state bar is only going to happen on that triggering event. And we're going to talk about where the state bar could name your attorney or that would be acting. And we're going to pull that from this list of attorneys that are willing to serve, which we're going to talk about in a minute here. Or the state bar would be acting. So yes, only at the time that you become an affected attorney would that matching happen. Great question. Okay, perfect. Okay, so I think I did, let me just double check, making sure I went over everything on this slide. Okay, perfect. So how to actually fulfill these requirements? So this is something that is active now. So the rules aren't effective, but you can get this done voluntarily now instead of waiting for license renewal. So this is something that is open now on our member area. So the state bar's member portal. You can go to the main page. So the main navigation has this Rule 21 heading. And the first subheading is interim administrator planning. And this would be where you can click and you can go through, are you in private practice, who you want to designate as your interim administrator, and they will get a nomination to accept or decline. So your interim administrator will actually get an email from the state bar where they can then go log in and accept or of course decline. So definitely be talking to who you are nominating so they know this is coming, they're aware of it, and there's no surprises there. Also, if you work in a like mid-sized to larger firm, there might be some sort of point person to say, okay, this is what you should do. So getting some information from them too, to see what the best course of action is. Serving as interim administrator is another subheading there. So these are where you would go to see if you have nominations to accept or decline, and view your Rule 21 emails. You will get an email actually sent to your email that the state bar has, but this is a way that you could go to this subheading here and kind of get the full, all your Rule 21 emails in one area. Okay, so once you go to that Rule 21 first subheading interim administrator planning, you will be able to hit edit, or I think it's select. My screen's a little bit smaller, so I think it says select on there, interim administrator planning, and that's where you'll be able to edit the answers to those questions. So yes, I'm in private practice, and that's the next slide. So once you hit the edit answer, you will say, yes, I'm in private practice, and you will have these three options. So if you remember, I said 2 options, but really 3. So there's 2 no cost option and 1 cost option, which gives you like those 3 options. So nominating an active Michigan attorney in good standing, nominating a law firm, or enrolling in the program. If you did this early and you chose enroll in the program, the fee, it won't actually be due until license renewal. So even if you select this option, it will only be an actual enrollment during license renewal. So once you completed your license renewal, it will confirm your answers, and then you will get charged that $60 at checkout. So if you chose nominating an attorney, you are going to have this drop-down search, which you would then be able to find that attorney that you're nominating. You're also going to see this when you nominate a law firm. So like we were talking about earlier, how if you have a law firm that you're naming, you're just typing it in. So we don't track law firms. We don't have an active list of current law firms. So you would just be typing that in, but then you'd be attaching an attorney to accept your nomination. So it doesn't mean that that attorney is your nominated interim administrator, but that the law firm is, and you just need to have an attorney employed by that law firm for us to confirm that you have designated an interim administrator. So timeline to responding to a nomination. So this, as soon as possible is best, but technically you don't have to have one until license renewal ends. So November 30th would be that cutoff to get this done. But it's always best to kind of get those accepted as soon as possible, which is why talking to that interim administrator is important. Okay, so when you get that nomination, your main navigation page would change. So you'd get this red action needed, which means that you have a pending nomination and you should go in and check that out and see if you need to accept or decline. So that would be right there for you. So it makes it really easy to accept or decline the nomination. You can, if you accepted and then things change and you need to withdraw, you can do that. Or if you nominated someone and you did it accidentally or things changed and you need to end or cancel, you can do that as well. So you will always be able to change your answers on the member area, except during license renewal, because it's done a little bit differently. But once you've done it through license renewal, you could go and edit that in this member area whenever. And the other thing is that let's say you accept your nomination or a nomination that's coming to you. So now you're someone's designated interim administrator, but then it comes time for it. Things change, circumstances change, and you're just not able to. You could then decline at that point as well. So there's a bunch of options. So this is the list, joining the list to serve as interim administrator. This is that list I was talking about. And this is also available in the member area section too. And it will be asked during license renewal. So if you want to join this list, this will be available to attorneys, but it's mainly going to be used for the state bar. So for us to locate an interim administrator for our enrollees, so those enrolled in the program, we want to say, okay, we can use this list to place your interim administrator. It's going to be filtered by practice area and jurisdictional area. But that doesn't necessarily mean that you have to have your interim administrator be in the exact same practice area as you, because yes, it may be likely that this interim administrator is taking over clients, and we'll get into specifics exactly how that would work, but they could also just be there to assist and help clients find new attorneys if you had passed away. So it doesn't necessarily mean that your interim administrator needs to be in the same practice area. So joining the list does not require that you have to accept or confirm a nomination. So that's still your ability to do that yourself if someone were to nominate you from the list. And your professional liability insurance isn't needed to join the list. It's only required for when you're acting as interim administrator. And this is where you would go to join the list. So that same main navigation, interim administrator planning, you would then click on edit your answer or select for join the list of attorneys willing to serve. And then it will request your practice areas in judicial circuits. Okay. So resources for attorneys. So again, that member area where you can fulfill your requirements now. There's also the Rule 21 website, which has a bunch of frequently asked questions and information on these new requirements. And you can always contact me. So contacting me at iap@mishbar.org or giving me a call on the phone. Either of those are great. So feel free to reach out as well. Now, this is really only the first step. So we're saying, yes, you have these mandatory requirements, but is that enough? And it likely is not going to be. So again, entering into agreements with your interim administrator, setting up your law firm so that if something did happen to you, you have it all set to go and ready for your person with knowledge to get the information that they need to give to the interim administrator to effectively make this transition. So best practice would be, looking at this at least every year, making sure that, your files have been at least somewhat audited, I would say. I don't know if audited is the right word, but gone through, sorting active versus non-active, making sure that your accounts are all in order, just really following best practices to make it the easiest for an interim administrator to come in. And we will have a lot of forms available soon. So we've been working on updating this succession planning page, and it might not be exactly on this page, but definitely it will be somewhere around here. We might have a new IAP succession planning versus just normal succession planning. But essentially we're going to have a template form for interim administrators and that affected attorney to enter into an agreement. We're going to have checklists. We're going to have limited durable powers of attorney forms, a fee agreement provision, a will provision for estate planning, because you want to make sure that your estate plan and your succession plan are cohesive. So we're going to have a bunch of resources coming soon. Definitely before September 1. My goal is mid-August. But that would be where you could find these forms. So we're going to have this like new guide. So right now, some of you might be aware there's a planning ahead guide or planning ahead handbook that's on that site right now, which doesn't have anything for Rule 21. That's going to be updated. Again, those forms and checklists. And we're working with SCAO. So we're working with the court administrator's office to have some SCAO forms. They won't be that you have to use these, but it definitely will be a benefit to use. Having some of these forms created so that when you are looking to be appointed for the circuit court, you have these SCAO forms easy to follow, easy to submit to the court for filing to get you through that process. So that's kind of what we're looking for in the near future. That's what I have for you guys. So I'll stop sharing here. I'll let Mark take it from here.
Yeah, April, there was when I was going through this stuff, there was some interplay with the Michigan rules of professional conduct that I found interesting in terms of, for those of us who are interested in being an interim administrator. And specifically, the rule states, excuse me, that there's not an automatic attorney-client privilege, but MRPC 1.6, which is the confidentiality rule, governs any conduct / contact between, the attorney, the interim attorney, and the affected person. So I guess, my question kind of becomes, do all the rules, because they're not specifically mentioned, are they excluded? Or when do all of the rules fully apply to the administrator?
Yeah, so the interim administrator should definitely, it's an attorney who's going to be acting, or if the law firm named, the law firm's going to be picking an attorney to be actually appointed. And so ethically, those rules of professional conduct, you're still applying those, but you're correct in saying attorney-client privilege is not automatic. So we have 1.6 that's applying confidences and secrets for that interim administrator when they're acting. But the attorney-client relationship, you really need the client to consent, and there is a specific rule in there regarding how that can occur, which is 9.317. So talking about that in order to establish that relationship, there needs to be that informed written consent from that client. And it needs to say that they're not. Oh, go ahead.
No, I was gonna say, that's interesting. So the interim administrator slash subsequent attorney can establish an attorney-client relationship with the client. But it takes certain rather specific steps to do that.
Correct. Yeah. So if this interim administrator is coming in, it doesn't mean that they're automatically the attorney, because the client picks who their attorney is. And so if that was the case where this interim administrator was stepping in, they are in the same practice area, affected attorney is permanently disabled or has passed away, and this client needs a new attorney rather than just like a temporary representation, then yes, that interim administrator could take on that client, but there needs to be that informed written consent, and it needs to say specifically that they are not required to, the client's not required to pick this interim administrator as their attorney.
Sure. And I think we should highlight that sort of, word to the wise. If you, as the subsequent attorney, as the interim administrator, if you're going to pick these folks up and start representing them, the rule specifically states language that must be included, presumably in the, retainer agreement or whatever it might be. But there is specific language that the subsequent attorney, to cover themselves and their bases, needs to include with, the new client. So read the rule, and everyone should be apprised of that. April, we've got 3 questions here.
Okay.
So let me go through them. Can you pay a fee and have a separate agreement for the interim administrator?
Like pay a fee to like using a no cost option, and you're paying your interim administrator yourself?
I believe so. Yes.
Yeah, definitely. So you can have matter of contract between an attorney and that interim administrator. Payment could be also included in that agreement, whether it be I probably wouldn't suggest to have it be ahead of time, but it could be, or what happens, or what kind of payment is met with regarding certain circumstances that happen to that affected attorney. So yes, payment is something that should be addressed. There is some language in the rule regarding compensation, but it is very vague regarding like actual and reasonable costs. So if that is something that was going to be set up in that agreement, you definitely can address it in there specifically.
All right. Our second question, and this is a critical one I wrote down myself. Are the interim administrators paid? How do we get paid if we want to undertake these tasks, right?
Definitely. So there is specific language within the court rules, the new court rules. So 9.313 talks about compensation, but again, it is just very reimbursed for actual and reasonable costs incurred in connection with the performance of the interim administrator's duties, is how the rule reads. And so that can come from the law firm. It can come from the affected attorney's estate or other means that a judge orders. So whether that be some other property. And those appointed, so those who are enrolled in the program, and then the state bar is matching that attorney to them. So the ones that we are kind of picking and matching, they can look to the state bar as the payment of last resort almost. So there is a specific section in there regarding interim administrators that we appoint.
One of the things that I noticed, speaking about payment, is the rule states that, there should be reasonable compensation. Has the state bar sort of thought through what, reasonable compensation is?
Right. Yeah. So we've been in talks with the AGC because they sometimes appoint co-receivers, but usually it's on a volunteer basis. So there has been quite a few talks to kind of figure out, okay, what is this going to look like when this comes to fruition? But we don't have specifics now on that, but that would be coming in future.
Would it be fair, the state bar does publish, because, we use this in the litigation world when we're, seeking attorney's fees and taxing costs, those sorts of things. The state bar does sort of publish, all right, what size of firm are you in? What's your geography? How many years of practice? As kind of a guide, would that be a fair assumption to sort of pigeonhole yourself into one of those categories and say, well, this is a reasonable compensation?
Yeah, so it's definitely going to be something that we're still working on solidifying, but we're likely going to be looking at, okay, what is fair and reasonable when we're looking at more like the trustee side. So during that admin for a trustee, person representative, things like that, we're likely going to be following more of that guideline than anything. But again, nothing's been solidly decided.
All right, and Gary asked, and Gary, I believe we've answered this, but his question was, will the state bar suggest language to include in a fee agreement? And I think the magic language is actually written into the rule. April, is that
Yeah, so
correct?
the language regarding specifically putting in that you need to have specifically that the client does not have to pick the interim administrator definitely would go in there. But yes, that is some of the forms that we're going to be publishing. We have drafted a fee agreement clause. I think I said free, but fee agreement clause, so that you can use that and insert it into your own fee agreements.
We have one final question. Can my wife be the interim admin that directs others?
Is your wife an attorney? Would be the question. So the interim administrator has to be an active Michigan attorney in good standing, or law firm with at least one other Michigan attorney in good standing. But the person with knowledge does not have to be a Michigan attorney in good standing. It could be anyone. So it doesn't have to be an attorney. It could be a spouse. It could be a paralegal, legal assistant. It could be another attorney that you work with, but you're not naming them as your interim administrator. So your person with knowledge, if your spouse isn't an attorney, would likely be the better suit for that.
And I apologize, I didn't read the question in full. It was below my screen. So can my wife be the interim admin that directs others, parentheses, office staff, to transfer files while my wife directs transfers of client monies? Is that the same answer?
Yes, it would be the same answer, because that interim administrator needs to be an attorney or law firm with another Michigan attorney in good standing.
Okay. All right.
Any other questions?
That appears to be all of the questions that we have. Let me just make sure nothing's in the chat. April, thank you.
Yeah,
Very helpful.
thanks for having me.
And as we all heard, she volunteered her services for all of us to the extent that we have follow-up questions. Hold on, we had another question
Yes.
pop up. Please contact April. Oh, will the PowerPoint be available? Excellent question. And
Yeah, I
don't
believe the
know-
recording. I think the recording will be available. I'm not sure if you guys have the ability. That might be a one question.
Yeah, I think I can answer that. The negligence section of the state bar tends to, and I suspect they will in this case, we can put it on our website. We'll keep we'll keep the, I don't know if it's a PDF or whatever of this session, but also we can put the PowerPoint up as a handy reference and guide for folks to, come back to. September 1's a long time away, so, there's always
Yeah,
gonna be questions.
less and less time. Yes.
Right, exactly. I know, but right, in lawyer speak, it seems like, forever away, but yes, I gather that the negligence section can put all this up on our website, and folks can go there to use it as a reference. Well, here we go from Owen, our IT guy. Recording the webinar will be posted to the YouTube account of this State Bar negligence section. And yes, I suspect we can figure out a way to put the PowerPoint up there as well. All right, we got a thank you. So with that, I think we have answered all the immediate questions. April, on behalf of the negligence section, thank you very much.
Thank you,
Very
guys.
informative for our members and our folks. And to be continued, right?
Yes, exactly.
All
Part
right.
two.
Part
Yeah.
two. Thank you,
All right.
everybody.
Yeah, thanks, guys.
Appreciate it.